Welcome to literary and jury charge practice. Let's get started with some jury charge. And the subject of this jury charge is drainage ditch, and it's one we've been working on. So we're going to try just a little bit more of it. And remember, it's good number practice. Okay, here we go. Let's give it a try. That the descriptions of the lands over which said proposed drainage ditch will pass are as follows. Northwest 1/4 of Section 3, Township 111, North Range 41 West. Northeast 1/4 of Section 3, Township 111, North Range 41 West. Southeast 1/4 of Section 34, Township 112 North, Range 41 West. Southwest 1/4 of Section 35, Township 112 North, Range 41 West. Southeast 1/4 of Section 35, Township 112 North, Range 41 West. Southwest 1/4 of Section 3, Township 111 North, Range 41 West. Northwest 1/4 of Section 10, Township 111 North, Range 41 West. Southwest 1/4 of Section 10, Township 111 North, Range 41 West. Northeast 1/4 of Section 9, Township 111 North, Range 41 West. That your petitioners are a majority of the resident landowners or the owners of at least 51% of the area of the land hereinbefore described. That your petitioners will pay all costs and expenses which may be incurred in case these proceedings shall be dismissed, or for any reason no contract for the construction thereof is let. Wherefore your petitioners pray that all proceedings necessary according to law to establish and construct said drainage system be taken pursuant to the statute in such case made and provided. I hope everybody was able to hang in there. All right, let's now try some more jury charge practice, different jury charge. And this one is, the subject of this one is interpretation of a state law. Ready? Here we go. This case presents for decision important questions regarding the applicability to the United States of the restrictions against stay of state court proceedings and the propriety of the injunction decreed by the district court and sustained by the Court of Appeals. Petitioner has filed a petitory action in a Louisiana state court against respondent mineral leases of the United States. In that action, petitioner sought to have itself declared owner of the mineral rights under land owned by the United States, and it also sought an accounting for oil and other minerals removed by respondent lessees under their leases from the United States. Respondent lessees filed exceptions in the state court proceedings, urging that under Louisiana law the lessor should be made a party and the lessees discharged from the suit. That this was essentially a suit against the United States, which had not consented to be sued. That the United States was an indispensable party, and that no cause of action had been stated. The state trial court found that a cause of action had been stated, and it overruled the exceptions. At this point, the United States, joining petitioner and other interested parties as defendants, brought the present suit in the district court to quiet title in the mineral rights. It also sought a preliminary injunction to restrain petitioner from prosecuting its action in the state court. The United States based its claim of ownership on the provision in the 1938 deed from petitioner's predecessor in title that the reservation of mineral rights would expire on April 1, 1954, subject to certain conditions not material to this case. The United States claimed that irreparable injury in the form of loss of royalties would result from any temporary wrongful dispossession of its lessees by the state court proceedings. Affidavits were also submitted in support of the claim that permanent loss of wells currently producing oil would probably result from any temporary cessation of production. The petitioner moved to dismiss the complaint of the United States on the ground that the state court had already assumed jurisdiction over the property in question. In the alternative, petitioner moved to stay the federal proceedings pending determination of the state court action because questions of state law were involved. The district court held that since the United States was not a party to the state court suit, the title of the United States could be tried only in the federal court action, and that an injunction against prosecution of the state proceedings should issue to protect its jurisdiction pending determination of the ownership of the property. Section 2283 provides that a court of the United States may not grant an injunction to stay proceedings in a state court except as expressly authorized by act of Congress or where necessary in aid of its jurisdiction or to protect or effectuate its judgments. All right, we'll rest for a moment. We did actually, let's look at some of the words we had in this one. We had petitioner, good one to practice. Respondent, lessees. Essentially. Predecessor, predecessor in title. Irreparable injury. Dispossession. Some good words to practice. All right, now let's try some jury charge. And we had started this article on how to network when you aren't a people person. Let's see what else we have to learn here. Ready? When crowds aren't your thing. I agree. They're not my thing either. Don't room with anyone. I rarely room with anyone to whom I'm not married. Not because I don't like my colleagues. I just need some quiet every day and in large doses. Do attend the receptions, but let yourself skip out when it feels time. When you think I'm such a newbie. We all were students and new reporters at one time. I wish I could have come to all these conventions when I was a new reporter, and I wish I read this article at that time. But since I don't have a TARDIS, I'll let the students and newbies what I wish I had known then. Observe and see who seems to be in charge, who seems to have their act together. Looks can be deceiving. Who embodies love for this profession. Introduce yourself to them in this manner I described a few paragraphs above. If you're feeling pretty bold, ask them to introduce you around. These are the people who want this profession to succeed, and by extension want you to succeed. Don't hang around anyone who spends more than 50% of his or her time complaining. If you have to get up and switch seats, do so. I'm serious. Yes, they are loved by God and they are human beings deserving of dignity and compassion, but they are toxic. You're here to be pulled up, not dragged down. Needless to say, don't be a complainer yourself. Thank the people in charge of putting the convention or conference together. If you've never been involved in the planning of one of these things, you have no idea of the challenges therein. Lift others up, and you find yourself lifted up as well. This is not being a Pollyanna pie in the sky. It's fact. If you have serious problems about something, speak to someone who can do something about it, and or volunteer to do something about it yourself. Sounds like I'm on a soapbox. I am. In conclusion, if you're feeling a bit of social anxiety, it's not just you, or at least I hope it's not just me. Right, back to some jury charge practice. Ready? It must first be decided whether this section applied to stays sought by the United States, because different answers to this question will put different aspects on other issues in the case. There can be no doubt of the right of the United States to enjoin state court proceedings whenever the prerequisites for relief by way of injunction be present. In United States versus United Mine Workers, the court did not rely entirely on the rule of construction because its reading of the act as a whole and the legislative history supported the conclusion that the United States was not to be included. In this case, there is no legislative material to support or to gainsay the applicability of the rule of construction. There is, however, a persuasive reason why the federal court's power to stay court proceedings might have been restricted when a private party was seeking the stay, but not when the United States was seeking similar relief. The statute is designed to prevent conflict between federal and state courts. This policy is much more compelling when it is the litigation of private parties which threatens to draw the two judicial systems into conflict than when it is the United States which seeks a stay to prevent threatened irreparable injury to a national interest. It is always difficult to feel confident about constructing an ambiguous statute when the aids to construction are so meager, but the interpretation excluding the United States from the coverage of the statute seems to us preferable in the context of healthy federal-state relations. The government contends that Act No. 315 of 1940 does not apply when the parties themselves have contracted for a reservation of specific duration, and that if the statute is construed to apply to this situation, it would impair the obligation of the government's contract. Petitioner contests these contentions. The Supreme Court of Louisiana has never considered the specific issue or even discuss generally the rationale of the statute, especially with reference to problems of constitutionality. All right, let's try this literary. The subject is the lesson behind your processing. This is written by Monet Benoit. She is a certified reporting instructor, and she wrote this for the JCR. Ready? The lesson behind your processing. Here we go. Years ago, I wrote about shifting a student's thoughts about processing. The student went on to become a court reporter, and I wrote about her path again a few years later. Over the years, I have been contacted by students, reporters, and instructors to expand on the topic with my tutoring and coaching. The sentence originated when I was teaching evening classes in the late 1980s. My students asked why they were not progressing in speed classes while putting in the hours, while enrolled in academics, while working full-time, and while arriving after a long day for a 4-hour evening. I saw their frustration as their expectations were not met. Students often flew through one speed to then sit in another. They were challenged by speed building, by typing up tests, by academics, and by nightly dictation. My parents, both degreed instructors, always asked about my students. My father particularly enjoyed helping me with these challenges. He listened as a guidance counselor, social worker, and father. My students work so hard. Sometimes I think they're working too hard. They become frustrated. Sometimes I think their frustration is part venting to progress, I said one weekend. Mr. Emmett, as my father was known to the reporting industry, replied, "The mind is like a sponge. The human mind has to take time to absorb the information. Tell your students that when they put a sponge into a glass filled with water, the sponge first absorbs the water. This is a process. They came into the court reporting program with an empty slate, learned new skills, and learned thousands of new words with steno language. Now their brain, like that sponge in the glass with water, has to take time for the new information to be absorbed. If time is not taken for the absorption or the process is interrupted, there is an overflow of water or a problem. I saw this when you were a student. You phoned from your dorm room upset and frustrated. I listened, encouraged you to go back to work, and told you that it would come to you," he continued. "Your students are learning a new language and new skills. When they fully process the information, they will progress. And it happens when a person least expects it. Yet the work has to be put in, has to with court reporting skills." We'll get back to that, and now let's try some more jury charge. Ready? The district court recognized that a problem of interpretation was involved, that the statute cannot be read by him who runs. What are the situations to which the statute is applicable? Is the statute merely declaratory of prior Louisiana law? What are the problems that it was designed to meet? The answers to these questions are or may be relevant. Before attempting to answer them and to decide their relation to the issues in the case, we think it advisable to have an interpretation, if possible, of the state statute by the Louisiana Supreme Court, which is the only court that can interpret the statute with finality. The Louisiana Declaratory Judgment Procedure appears available to secure such an interpretation, and the United States, of course, may appear to urge its interpretation of the statute. It need hardly be added that the state courts in such proceeding can decide definitively only questions of state law that are not subject to overriding federal law. We therefore modify the judgment of the Court of Appeals to permit an interpretation of the state statute to be sought with every expedition in the state court in conformity with this opinion. All right, just had a bit to finish on that one. So let's start this new one. And the subject of this jury charge is recovery attempt by heir, like the heir to the estate, H-E-I-R. Recovery attempt by heir. We'll just read a bit. Here we go. Members of the jury, it now becomes the duty of the court to charge you in the law that applies to this case. This is an action on behalf of Marion M. Johnson as the plaintiff against the American Life and Accident Insurance Company of Toledo, Ohio. The plaintiff, for her cause of action against the defendant, sets out the corporate capacity of the defendant company, that its principal place of business is in Toledo, Ohio. For her first cause of action, the plaintiff says that she is the widow of Henry O. Johnson, who died in October 1955, and the owner of a parcel of real estate situated in the city of Columbus, Ohio. She further says that the estate of Henry O. Johnson was subsequently administered in the probate court of Lucas County, and that she, the plaintiff, was the sole heir. As such, she is now the owner of this particularly described piece of real estate. And we'll stop there, and that will conclude our literary and jury charge practice.